Thank you. I'm going to talk about my favorite topic today, the United States Supreme Court. Topic seems particularly timely since our president announced the newest Associate Supreme Court Justice yesterday, Judge Ketanji Brown Jackson. But I'm not going to talk about her, and I'm going to go to that. I'm not going to talk about her. I will talk a little bit about the confirmation process, but what I really want to examine is sort of the status of the court and reforms that have been suggested about the court and my perspective on that, frankly, as a practitioner. So I think most of you probably have some rudimentary understanding of what the court is, right? It's the highest court of the land. It is the head of the judiciary, which is one of the three coordinate branches along with Congress and the president. At the time of the framing of the Constitution, it was expected that it would be the least dangerous branch of government because it has no ability to raise money, can't raise an army, can't even decide the issues that it thinks are important. It has to wait for cases or controversies to come to it in order to decide them. But the one power that it was given, and the most significant power it has today, is judicial review. That is the ability to say what the law is and what it means, to determine what the Constitution means and what Congress's enactments mean and how they apply to individuals. It's an extraordinarily important power because it constrains the authority of the executive branch and the legislative branch, and frankly of the states, and it fundamentally protects the individual rights of all of us. My relationship with the court is, however, not kind of a stick figure civics analysis. I started as a law clerk to Warren Burger in 1978. As the gracious introduction suggests, I've been arguing before the Supreme Court for 40 years. I don't view the justices as stick figures. I view them as real people. Many of them I knew before they went on the court. All of them I've known since being on the court and having the opportunity to argue in front of them. And in many ways, I think my own professional legacy is tied to the standing of the court in the eyes of the public, which is why I've been concerned, because most of my professional life, the approval ratings for the Supreme Court or in all the courts, frankly, have been around 60+%. And only recently has it dropped to around 40%. And that's disturbing to me because the power of judicial review is tied up with the legitimacy of the court itself. And if the public doesn't believe that the court is acting independently, if it loses that legitimacy, the ability to exercise that authority to constrain the executive and legislative branches to protect our fundamental rights disintegrates, or at least potentially can, and that's inappropriate. Now, we all know why this has happened, at least in terms of the approval ratings. Obviously, the Senate fundamentally changed the rules for confirming justices to the Supreme Court. The filibuster rule that used to require 60 votes in order for a justice to be, and all judges to be confirmed was eliminated. And so now you end up with 52 and 53 votes to have someone confirmed. Gone are the days when Justice Scalia became justice with a vote of 98-0, or Justice Ginsburg, who's on the exact opposite end of the spectrum, is confirmed by a vote of 95-3. Now we have these much more partisan divides. And of course, the fact that the Senate left a vacancy open on the Supreme Court for more than a year and then raced to get another nominee through in fewer than 2 months, and therefore created an imbalance, at least perceptually, in the composition of the court, with 6 of the justices having been nominated by a Republican president and 3 by a Democratic president, created a bit of a partisan uproar, and candidly forced then-candidate Biden, now President Biden, to commit to creating a commission that would study the court and to evaluate whether or not there are important reforms that ought to be developed. And 3 of those recommendations, three of the proposals that they analyzed, I'm going to talk about today. The first one is, what's the right size for the number of justices on the Supreme Court? Second is, should there be term limits? Justices currently serve life tenure. Should that be changed. And then the third one is cameras in the courtroom, whether or not the public proceedings of the court ought to be broadcast live on television or otherwise or not. And let me be clear about this. As I evaluate these categories, I am not analyzing them as a political matter or as a partisan. I'm analyzing them as a person whose life is very much bound up with the institution itself. And so what I'm looking for are ways that will ultimately improve how the institution does its work, and ultimately then ways that will benefit the nation, because the judiciary remains independent and can conduct the kinds of judicial review that the nation can respect, whether or not you agree with the final decision that comes out of the Supreme Court. So let's turn to the first one. What's the right number of justices on the Supreme Court? The Constitution doesn't have a number. It doesn't say how many judges should sit on the Supreme Court. There have been 9 since 1869. That's a pretty venerable tradition. But prior to that time, there had been as few as 5 and as many as 10. I will say categorically that if they want to monkey with the number on the court, it should not be an even number. And the reason for that is the court is supposed to say what the law is. It's not supposed to simply decide cases. An equally divided court simply decides the case in front of it and can say nothing about what the law is, which defeats the primary purpose of having a Supreme Court in the first place. So that you can take off the table. The other side of the coin, and this is based on my personal experience having worked at the court, trying to get 5 justices to agree on a single opinion is an extraordinarily complicated, cumbersome, time-intensive process. And I think it's important that you realize how hard that is and how much we should respect the fact that this court achieves that in every case that it hears in every term. And so that by the end of June, you will get an opinion from the court that tells you the outcome of your case and why it was reached under those circumstances. That is an extraordinarily efficient operation, much better than the vast majority of courts, frankly, before whom I appear, where you can wait years before you get a decision. So this court decides the most complicated cases, the ones that have divided lower courts hopelessly, and has done so in a way that people can only admire in terms of getting the work done in a timely fashion. That, frankly, stands in stark contrast to the other branches of our government. So I think it's important when evaluating any changes that we should not lose sight of the important efficiencies that come from the number 9. So if you increase to 11 or 13, what will the impact be? It's going to be that much harder to get any kind of a consensus. You'll have more fractured decisions, and the law will, frankly, not be as well served as it is today. So then the question becomes, what's the argument for increasing the number? And frankly, the only real argument now is to rebalance the court. And if you're really going to take that seriously, then you'd have to add 4 more justices, which takes you to 13. Now, is 13 a number that you can look out and find a model for in any other court system? No. There are no state courts that have 13 judges who sit on their highest courts. Candidly, there are only a handful of nations that have that many, and they don't sit as entire courts when they hear cases. So this would be totally uncharted territory to go off in that. But more fundamentally, what's going to happen is, if one side chooses to go to 13 today, the next time there's a change in power, we'll go to 15. And the time after that, we'll go to 17. And what will the perception of the court become? It will be that it is a political tool, that it's not operating independently, that its judicial review is not legitimate because it simply changes with the political winds of our nation. And that's a fundamental mistake, and we should not embrace that approach as a solution to the imbalance that exists today. Now, the second proposal, I think, actually does have some models out there that give it stronger force. And here we're talking about term limits. Indeed, the United States judiciary is alone. It by Constitution, provides life tenure The purpose of that was clearly to ensure the independence of the judiciary, and it certainly has fulfilled that function. But the truth is, all of the states and most other countries that use judicial systems like ours also seek judicial independence, and every other country and every other state except for one provides either term limits or mandatory retirement ages. Very few instances of allowing judges or justices to stay on for forever, seemingly. And I will tell you now, as someone who has practiced before the federal courts for more than 45 years, that there is not a single judge nor justice about whom I would say categorically is better at their job after 15 years than he or she was after 5. To be sure, some are just as good, not saying there's always a degradation in talent, but it's very hard to maintain the rigor, the enthusiasm, the energy when you're doing the same job day in, day out in an isolated environment for more than a decade. And so I would argue that the quality of the judiciary would be enhanced pretty significantly by term limits. It has to be done by constitutional amendment, but I think that's an amendment that I hope the nation will embrace and will move forward with. The flip side advantage, of course, is if you're not picking people who will be there for the next 40 years, hopefully the confirmation process will become significantly less contentious. And it won't eliminate contentiousness, to be sure, but it'll make it less so. And anything that makes that process less political, it seems to me, will enhance the legitimacy of the court and ultimately the value of its judicial review. The final proposal is cameras in the courtroom or broadcasting publicly the court's proceedings. Here I'm a huge proponent of that reform and have been for quite some time. And again, this is a situation where a lot of other courts have gone down this path. Almost every court of appeals streams live. The Supreme Court could do it. I can't tell you how much it kills me to know that the technology existed, that we could today have video of Thurgood Marshall arguing Brown versus Board of Education, probably the most important case in the history of the Supreme Court, certainly one of them on the desegregation of school systems. We don't have it. We have audio tapes, but there's no substitute for video. The reality is the pandemic has forced the court, because it closes itself, to allow audio release on a simultaneous basis. I think that's a huge move in the right direction. But the truth is, I have personally argued in courts where there are cameras, and I can tell you that no rational being is going to stand at a podium in front of 9 hostile or potentially hostile human beings looking at him or her and play to the camera. You are going to make the argument the best you can. And if the public could see the same court I see, you can come away with nothing but respect for the quality and the hard work and the determination of those individuals. Again, you may disagree with them, but you will at least respect that they do their own work and they are extraordinary in that respect. So at some, I hope the court does not change the number, the nation doesn't change the number of justices on the court. I do hope that we have term limits in the not too distant future, and I would love it if there were cameras in the courtroom before I finish my tenure. Thank you for your time.